fact of the matter is that the Seneca Nation and dozens of other Indian nations are at least as sophisticated, if not more so, in terms of management, security, oversight, and regulation than the biggest and best operators in Atlantic City and Las Vegas. Tribal job creation and economic diversification in our regions should be respected, protected, and cultivated, not attacked, undermined, or assaulted. The Seneca Nation, like dozens of other Indian tribes, is one of the largest employers in our geographic region. Collectively, tribal government gaming injects billions of dollars into the regional economies that surround Indian country. Tens of thousands of American workers, both Indians and non-Indians who are our neighbors, depend on the health and vitality of tribal government gaming operations for their jobs. These jobs exist directly or indirectly, such as through the contractors and vendors who rely upon our gaming enterprises for their livelihoods. These family breadwinners have invested their lives in Indian gaming as chefs, as slot machine technicians, as construction workers and suppliers, and so on. In an unbelievable and ironic twist of fate, it can literally be said that many Indian nations and tribes carry the responsibility of feeding and clothing our non-Indian neighbors along with our own citizens.
I think that tells us to some degree we don't need each state doing it individually because they all have the same interest, and it would be far more efficient to have one entity at the federal level that does that handles that regulation of gaming. And that entity at the federal level should be keenly focused on protecting the importance of Indian gaming to Indian tribes, because we have created a resource here, $30 billion in 2009, that is being used by tribal governments all over the country, and it's absolutely fundamentally important. Internet gaming causes some risk to that very strong revenue source, and if that revenue source goes away, that's going to be federal responsibility to meet those needs.
If you look over all the federal statutes, they all require that the gambling be illegal for the federal statute to apply. The only two exceptions are the federal anti-lottery statutes, which have express exceptions for state lotteries, and the Wire Act. The Wire Act was the main weapon that was used by the Department of Justice in its war of intimidation to try to scare players, payment processors, and operators out of the American market. That weapon is now gone. There are at least 6 state lotteries that are already selling lottery tickets through the internet by subscription. They now can sell individual tickets. The big question is, will they go with instant lottery? Because if you put a scratcher on a video screen, it becomes almost indistinguishable from a slot machine. In New Jersey, where there are no tribes, New Jersey will be legalizing internet casinos this year, and all of the licenses will go to Atlantic City casinos. If Connecticut legalizes, then the 2 licenses will go to the 2 large Indian gaming tribes. But in every other state, where the tribes are going to be forced to do is basically compete for a very limited number of licenses. The problem is, and I looked at this law very carefully, under Cabazon and IGRA, the tribes have 2 tests. You look to see what is permitted in the state, and then the tribes can do it. But it seems to me pretty clear the courts are going to say they're limited to taking bets from people who are physically on their land. Now, they can take bets off reservation, but that's if and only if the states agree. In other words, for a tribe to do internet gambling and take patrons who are off reservation, that's a privilege, not a right. So the question is, what is this going to mean for the tribes? And in some cases, the big tribes, the ones that are well established, can protect themselves. They've got the political power, they've got compacts in place. But it's really up to Congress to protect the rest, particularly small tribes that are not near cities, that are basically not going to be getting the licenses and are now going to have this additional competition with no reason to go onto their reservation to gamble. In fact, one point that I want to raise that hasn't been raised, it's not even clear that tribes can keep internet gambling off their land if a state legalizes. There's some precedents that say state lotteries can sell on Indian land. In 1962, there were no state lotteries in the United States. Half a century later, we have state lotteries in every state with only a half a dozen that don't have state lotteries. But the internet, the speed of change on the internet is like dog years. It's not going to take 4 or 5 decades. Within much less than 1 decade, we're going to see internet gambling legalized by all the states. And unless Congress figures out a way to protect particularly the small states, I think that a lot of the tribes are going to be out of luck.
So I think in my mind, IGRA has 3 major components or ideas. First, it respected the victory that the tribes gained in the Cabazon case, which I'm sure the next witness will mention. And that means that tribes have a right to conduct gaming as long as it is not prohibited in the state where they are located. And I think that bargain should still be upheld. Number 2, we made a decision when we drafted the very first Udall bill, and I think Morris Udall was the first one that introduced a bill regulating Indian gaming, that gaming was going to be limited on the reservation to tribally owned establishment. So in effect, we viewed tribe as both the owners and the regulators of gaming. I'm here to testify about why, if internet gaming is otherwise legalized, the special problems of Indian should be taken into consideration. And I think there's 2 reasons for this. One, for sure, for many Indian tribes that have tribal state compacts, internet gaming would be legal under their compacts. There's no reason to treat internet gaming as a new form of gaming. If there is poker that is allowed as a form of gaming, internet poker should follow. However, for other tribes, it may not be the case. If so, as a result of the Seminole Tribe versus Florida Supreme Court decision, those tribes would have a very hard time amending their compacts, since under that decision, tribes can no longer sue the state if the state in federal court if the state raised their sovereign immunity rights. Number 2, and this is Professor Rose alluded to that, even for those tribes for whom it is legal under their existing compact, they may be restricted to wagering originating on Indian land. This limitation, in effect, makes no sense when it comes to internet gaming, since internet gaming is borderless. And the reason for that limitation is that IGRA was enacted with a concept of land-based sovereignty that is just not easy applicable or translatable when it comes to internet gaming.
20 months elapsed between the time of the Cabazon decision and the date that the Congress passed the Indian Gaming Regulatory Act in 1988. And what must also be kept in mind, though, is that Congress had actually been considering Indian gaming legislation 3 years before the Cabazon decision came down. So at the time IGRA was enacted and signed into law by President Reagan in 1988, Congress had devoted more than 4 full years to that legislative process.